Gentlemen, welcome and thank you so much for joining us. Welcome on to the program. Let's get started, shall we? I'm going to start with you, Mr. Tochukwu. From a legal standpoint, how damaging is the DSS admission that no weapons were found during Kanu's arrest?
Thank you very much for having me. Before I delve into this discussion, I want us to understand that this matter is still pending before the court, and so whatever I'm going to say will have to be limited so that I won't be committed for subjudice. Having said that, it's important for us to understand that what the witness has said somehow would have assisted in helping their case so that it will weaken the prosecution's case. In any case, I have said several times that the case that's surrounding the trial of Nnamdi Kanu is more political than legal. Otherwise, several occasions the court has granted him bail and he's still being held under custody. I do not think that the state are being compliant with the due process of law. And because of that, it is important that at this period, the state should be able to follow the due process of law and comply with the rules of law. If the court has granted bail, the state should comply with the bail terms. After all, it's just bail. He can always be produced to court to come and face his trial whenever he is required. If the witness has said they have not found anything incriminating, then the court should sit on the matter and distill it appropriately and see whether or not he is guilty as charged. That's not enough to say that the fact that one so witness said he had not found anything incriminating does not mean that other evidence that have been adduced will not be considered in the matter. But in any case, at the end of the day, he should be able to be granted bail, at least on the face of it. He should be able to be granted bail.
All right, thank you, Tochukwu. Let's come to Joshua Imarayi. Joshua, you've been following this story for quite a while, so maybe you might have been able to gather some off-the-record type information. So with everything that's happening now, this DSS revelation, what does this testimony mean for the credibility of the state's terrorism case against Nnamdi Kanu? What are they saying in the corridors of court?
Well, you are aware that this case has been going on for so long, stemming from October 16, 2016, when he was arrested after going into the hotel. Before then, he was granted bail, and they accused him of jumping bail when some security operatives stopped his residence at the same time where he actually fled the country. Now, you recall that he was extradited from Kenya, if I'm not mistaken, where he was brought back to Nigeria. Now, the whole thing is complicated, right? Because the actual government that is actually bringing Nnamdi Kanu to court is no longer in power. That's the government of President Muhammadu Buhari. That's ex-President Muhammadu Buhari. Now, we are seeing that the case is back again afresh from the new judge. Initially, it was Justice Imarayi, who was assistant of the state for the action. Justice Imarayi had to recuse herself from based on the demands of Nnamdi Kanu. And the case was allocated to another judge. Now Justice James Omotosho, now sitting on the case. So far, the counsel is investing now and it's comfortable with Justice James Omotosho saying that his counter
Joshua, my apology, Joshua. I'm going to stop you. Joshua, I'm going to stop you. I'm going to please implore that you please disconnect the Bluetooth device you're using, because while you can hear us properly, we are unable to hear you. So if you could please adjust that. Now, while you're doing that, I'm going to come to Tochukwu. Tochukwu, let's talk about the court now and every due process. Let's talk about due process. Do you think that due process was followed in this case, as has been told against?
Well, when you say whether due process was followed with regards to the trial, the answer to it is neither yes nor no. The reason is that whether or not due process was followed is no longer relevant here. What is relevant is that he has been arrested and he is in court to face trial. And whether the court is going to grant him bail is also determined by what the defendant has submitted before the court. But it's on record that ever since he has been facing his trial, several occasions the court has granted bail and the state has refused to comply with his bail. And that's the reason why when I started, I said that his case is more or less political than legal, because on the face of it, in law, he has been granted bail, the state has refused to grant him bail. The witness has even said, the state witness has said that they have not found anything incriminating, based on the evidence they have gathered against him. Then if you have not found anything incriminating against him, why are you still holding him? I think it is important to understand that the state is actually arrogating themselves as the umpire of the law, and that is not supposed to be, because every institution is created by law, including the office of the president. And if the office of the president and that of the attorney general have refused to comply with the rules of law by granting bail to Nnamdi Kanu, it becomes a threat to our nascent democracy. And that's why we are calling on all the state apparatchiks to understand the intricacies and the sensitivity of the case of Nnamdi Kanu, to grant him bail, at least for him to have access to his family and then be able to come for his trial.
Okay. Joshua, I'm wondering if Joshua's, if we can hear Joshua properly now. Oh, I think he's trying to reconnect, so maybe...
We seem to have lost Joshua there, but let me ask you, Mr. Tochukwu, about, just in your view, about the public and IPOB community. What has been their response like to this testimony, and do you think it will have any implication on the security, or better yet, the case?
Before now, the IPOB has been proscribed. So whatever activities that is going on in the Southeast in the guise of IPOB remain proscribed as far as the law is concerned in Nigeria. So for that reason, whether or not they are positively reactive to what happened in court or not, their activities still remain proscribed in Nigeria. However, it is important to note that by releasing Nnamdi Kanu, even on bail, it will help to reduce the level of insecurity in the Southeast, because most of these agitators are basically tied to the grievances that is being laid against the arrest and trial of Nnamdi Kanu. So I believe that, in my view, if Nnamdi Kanu is being granted bail, it will help to reduce the insecurity in the Southeast, and also to mellow down the tension that is being already high by the IPOB agitators in the Southeast. However, it's important for us to note that whatever activity that is being carried out by IPOB in the Southeast, either as a result of grievances of the arrest of Nnamdi Kanu and his trial or not, is still proscribed and against the law, because the law has said so and the government has so proscribed it to be. And that's how it should be, until subject to whether or not the government is going to review it.
So at this point, one has to ask about, the precedents this case will set for future arrests and trials involving charges of terrorism or even political agitation.
Unfortunately, it's already setting a bad precedent for our constitutional democracy, because the reason is this. Ordinarily, as a general rule, bail is grantable. Any offense can be granted bail, except with exceptional circumstances such as terrorism, which is what he's facing. But even at terrorism, the court can still have the discretion to grant bail if it finds merit on what you presented before it, for which the court has done that. The court has done that by granting him bail in several occasions, despite the fact that the offense through which he's been alleged of and been tried of is not a bailable offense. But the court, in its magnanimity, has granted him bail in that circumstance, but yet the state has refused to grant him bail. So these are issues that has to face with, these are issues that we have to face in terms of the threat to our democracy and the threat to our rule of law. The state cannot choose the law to obey and the one not to obey. If the court has said grant someone bail, you have to comply with the terms of the bail. And I'm very sure that Nnamdi Kanu with his legal teams are willing to comply with the bail terms and should be granted bail as such. But you see that the state are still holding him. So the precedent is already bad on the face of it, and we pray that it doesn't degenerate to something else that will make people to go against the order of the state.
Worst case scenario. Joshua Imarayi is back. Joshua, thank you for coming back. I'm hoping that we sorted your audio quality. I was asking earlier what you've been hearing, what you've gathered, what other off-the-record information you've gathered regarding the case and the revelation by the DSS operative.
Well, there are echoes around town that the case against Nnamdi Kanu seems to be political, and from presidents and antecedents, they are seeing that it's connected political. Because why the case was initially initiated when President Muhammad Buhari was in power. Now President power. Now, what we are seeing and the echoes we are hearing in the court is Nnamdi Kanu is likely to be granted bail within any moment from now. Because why? The first witness, that was the PWA, it was presented, was said to be the star witness in this ongoing trial. And from testimony so far, the only thing found in Nnamdi Kanu's custody is radio equipment and the likes. No weapon of terrorism was found. And previously, he was granted bail under Justice Peter. I'm trying to recall this Justice Peter. Yes, it was granted bail, but unfortunately, the DSS seems to find their way around. But now, we are hearing that he might be granted bail. And if it's granted, we are hoping to see if the DSS will allow it guilty or he will still be held back. I need to remind you that this case has started from the top. Initially, it was ongoing report, but was brought down to Justice Omokocho. Now it's starting from the top. And the way it is, I'm quite sure that with no time granted bail, and the vote will be watered down.
And just lastly, I think I have to ask the both of you, but let me start with you, Uthman. What would be the next step legally to resolve this case in a way that respects national security, but most importantly, human rights?
Well, like in criminal trial, the onus of proof, the burden of proof is rather on the prosecution to prove it is beyond the doubt. Once there is any single iota of doubt, it means you have failed to prove your case, and that means there won't be any grant of conviction on the part of the defendant. So the next thing will be that on the next day of adjournment, both parties will come back to court and look at their pleadings all together, and then the court will take a decision whether or not this matter should continue or be struck out based on the fact that has been adduced before the court. As it stands, that particular evidence that was given by DSS on Friday would help a lot to strengthen the case of the defendant. And I believe that on the strength of that evidence, the court would rely on it heavily to either strike out the matter or ask Nnamdi Kanu to go home and decide and acquit him. But till then, we'll wait. Let us not preempt the court. We'll have to wait until the court sits, and then we'll hear how they are going to resolve the issue.
This question has been on my mind, and I think I want to ask you, Kingsley, just rather Uthman Tochukwu, just speaking, right, legally speaking, the testimonial by the DSS, does it have any bearing on the outcome of this case? Will it change it in any form, shape?
Sure, it does. It does because the DSS is the state. DSS is the state, and because they are the state, that's why they are even called to to come and give testimony in that particular matter. So whatever witness, whatever testimony they've given on the matter is going to have a lot of strength, and it will go a long way in determining the case, either positively or negatively, and that is it. Yeah, it does have.
So, Joshua, public perception now, what are people saying? We talked about inside of the court, but what are people saying regarding the situation, especially noting that it has a very big influence on things that are happening inside of the East with all the agitation that's going on there? What have you heard?
Well, most Nigerians seem to be on the side of Nnamdi Kanu. I don't know, there's this perception that is strengthening over time. But allegedly, whenever the government wants to go against anybody who wants to go, they use the instrument of the state. They are just saying that this is another case of one being at the receiving end of the instrument of the state. Well, we can't say much unless the court finds otherwise. So we are hopeful at the end of the day, both parties will reach, should I say, an agreement to let Nnamdi go or if he stays.
Well, gentlemen, I must say thank you for taking out the time to join us this morning. Tochukwu, that's Mr. Uthman Tochukwu, who's a legal practitioner, and also to our very own Joshua Imarayi, both of them joining us live from the capital, Abuja, to give us a bit of insight following Nnamdi Kanu's case.